Welcome everyone. Thank you for being with us this morning. This is a seminar we've been doing now for about 2 decades for companies throughout the United States, professionals, business owners, entrepreneurs. We've done it in all 50 US states, several countries around the world. And one of the reasons we've done it so much is that the information we're going to give you is information that has been through the courts, it's been through the IRS. There is no guesswork, there's no fluff in this presentation. Our strategies are used by companies like Marriott Hotels. They're used by the New York Yankees. They're used by Oprah Winfrey's staff, big real estate investors like Arnold Schwarzenegger, etc. So there's no fluff in our presentation. It is all content. And before you're done, we're going to give you a very, very specific plan that you can take with you. So what I'm going to suggest for the short time that we have together, because we're going to concentrate on the 3 most important elements of planning for businesses, and I'll show you that specifically in a minute. I want to keep this very focused, want to keep it very simple, and want to make sure every person watching us today gets a very specific picture and is comfortable with the information. And by the time we're done, you feel like you can go back to your attorneys, your accountants, and you can say, look, we need you to do this. So with that said, let's look at what the most common problems are for business owners in America today, entrepreneurs, etc. The biggest challenge that faces professionals, business owners, and investors is getting their legal documents in order. If your legal documents are not in order, you can't be sure what will happen if you go to court, if you pass on, or if you try to sell an asset. In fact, think about this for just a minute. Right now, every one of you has made a decision, and that decision is you've already decided what's going to happen in the event you go to court or if you pass away, because the legal documents you've already signed are making that determination for you. If you don't know what those legal documents are doing, then you're really only managing half your business. So let's take a look at some of those documents today. Now, we're just going to talk about a few of these, but I just want you to be aware, and then we're going to pick and apply the ones that really work for you. Joint tenancy is the most dangerous way to own an asset in America. Now, there are a number of states that are specific joint tenancy states, but in almost every state, the tendency of the court is if you cohabitate or you're married, that everything's joint tenancy. So the reason we say joint tenancy is the most dangerous way to own anything is, let's say that you get sued for something that happens at your business or because of your business, or who knows, maybe because of something a partner did or somebody in your family did. And you get sued, there's a large judgment, they go after all of your assets. If they're in joint tenancy, they go after everything you've got. So that could be your car, it could be your vacation home, it could be pretty much everything you own. So we're going to show you a little bit later where to put each asset so that no matter what you own, whether it's just a business, maybe you own the building the business is in, maybe you have your home, maybe you have a rental property, maybe you have a lot of rental properties. We have owners who own, for example, doctors or dentists who may own more than one practice. Maybe you own a bunch of properties and you have family members who help you out with it. You know, how do you know you're 100% protected from the people who help you do what you do every day? So joint tenancy is the most dangerous way to own an asset. We want to make sure you separate those out. The second one, tenants in entirety, we won't talk about very much. It's not used in every state. Sole proprietorship is it's amazing to me, but it still is a very common way to own a business. Sole proprietorship means that everything is in your name. So clearly, if you're targeted for a lawsuit or you pass away or something, everything goes in one big lump and they all go after it. The second is a C corporation. Now, the C and the S corporation, most business owners are really familiar with them, but let's talk about them for just a second. The C corporation is the longest running corporation in America. It has been around over 200 years. Because of that, it has by far, and it's not even close, it has by far the greatest tax advantages of any corporation ever created. But it has some drawbacks in terms of the amount of paperwork required and, little things like that. In fact, my guess is that for many of you, if you went to your accountant and you said, well, I'm starting a business, they didn't suggest a C corporation because of the amount of paperwork and some of the other issues with it. However, I want you to think about this. If you wrote a large check to the IRS during tax time last year, if you write a large quarterly check to the IRS every single quarter of the year, and you do not have the tax benefits of the C corporation, you need to have a conversation with your accountant. And I'm going to show you an inside secret today that is used by virtually every wealthy family in America, every large business, every successful wealthy individual. And that is how to get all of the tax advantages of a C corporation without ever creating one. It's one of the truly great strategies. A little bit later here, I'll show you exactly how to get that. The second method of ownership is the S corporation. Now, the S corporation has been around about 45, 50 years. It was designed for people who do not have a lot of assets. In some states, if you're a professional like a doctor, an accountant or something like that, you have to have an S corporation operating your business. So the S corporation, there's nothing wrong with it, but because it's fairly new, it has fewer protections than a C corporation and far fewer tax advantages. But if you already have an S corporation set up, we're not going to suggest you change it. We're not big believers in having you change everything you've got just to create more legal expense and have more legal documents. What we'd rather have you do is just pick and choose the correct documents and let them do what they do for you. The next item is the LLC. My guess is that everyone in here is intimately familiar with LLCs. In many states, you hear them advertised on the radio. You're constantly being told, look, a limited liability company is the way to go. And it can be, and it is one of the truly great tools, but it's also very new. The LLC we have today was created in 1996, so it's our newest legal tool. Because of that, there's only a few states that have case law protecting an LLC. So if you set up your LLC and put your equity in a state where it already has case law protecting it, it is the greatest single legal tool we have in America today. And I'll show you exactly how to do that. You can use it in conjunction with your existing tools if you want, but it gives you so many advantages. Now, one drawback, and I want you to be aware of this, and for those of you who already have an LLC, I'm going to make a suggestion that when you get home, you're probably already home, but maybe later today or whenever you have a chance, take out your LLC and open it up. Because the vast majority of LLCs that come off the shelf, and by off the shelf, what I mean is you went to your accountant and your accountant said, yeah, I've got an LLC here. He downloads it from his computer. You go to your attorney has an LLC on the disk with all the other legal forms, and all they do is download the form, or you call somebody like LegalZoom that has a standard form. I want you to open up your LLC, and generally you're going to find it in the 2 series paragraphs. It'd be like paragraph 2.1, 2.2, 2.3. Again, I don't know where you got your LLC if you have one, so I don't know exactly where you're going to find it, but it generally is there, and I want you to look for 2 words. And these 2 words are the most damaging 2 words in a legal document in America, because if they are in there and you go to court, they are guaranteed that you lose. And my guess is if you have an LLC, the reason you got it is because you wanted protection. The 2 words are mandatory distribution. Mandatory distribution. You'll find those 2 words together. And what they mean is every year you have to distribute all of the money that's in your LLC. So if you get sued, they simply go after the money. You have no way to stop them. They take your money this year, next year, every year until everything is finally settled. So the LLC can be a spectacular tool, but it needs to be done properly. Before we finish today, you'll know exactly how it operates and where it should be. Below that, you see the limited partnership. The limited partnership is kind of like the founder of asset protection in America. The very first lawsuit that ever involved protecting a business was in 1961 in South Dakota. The attorney who created the strategies we're talking about here won that case. And that case allowed a business to operate and separate all personal assets from the business assets. So if you did get sued, if you did go to court, then you never had to worry about your personal assets. And I want to spend a minute on this because it's so critical to so many of us in business. Because for many of you, your business isn't just your business, it's your life. You started it when you were young, you grew it, maybe you have employees today, maybe you don't, maybe you have a lot of employees, maybe you have more than one location. And over the years, you put a tremendous amount of sweat, a tremendous amount of time into it. And those hours that you invested in your business have allowed you to build a personal estate. So maybe that's a vacation home, maybe it's a boat, maybe it's an airplane, maybe it's a whole series of rental properties or something like that. And you're saying to yourself, if I get sued, I don't want those to be involved in the lawsuit. Well, the limited partnership gives you the ability to separate those out and make sure they don't get named. But we have a huge advantage today. You see, the limited partnership is kind of a cumbersome document. It has a lot of moving parts, fairly expensive, a lot of maintenance. Today, we can take a piece of that limited partnership, put it in your LLC, and get the same protection, the same tax advantages, a whole lot cheaper. If nothing else comes out of this seminar, this is going to be the most important thing you're going to learn. How to use the LLC to get all of the tax benefits of a C corporation and all the protection benefits of an LLC, of a limited partnership. Really a powerful point to learn. It's really fun to be able to teach you that. The next part's down there. I'm only going to spend a minute on because we have limited time. But when we look at wills and we look at living trusts, the passing of people today has become the most expensive event and probably the most damaging event in the life of any family. So think about this for a minute. Some of you probably have had a situation where a family member passed away. Everything went into probate and the estate it was either devastated or the time was incredible or there were fights among family members and it just dragged on and on and on and on. And you wondered why it dragged on. Well, in just a second here, I'm going to show you exactly why that is. Do you need a will? Do you need a trust? Yes, but you need them properly. We won't get into the charitable remainder trust, although I'll just throw this out quickly. It's something that we talk about in our longer seminars. If you have a sizable estate, maybe $5, $10, $15, $20 million, and much of it is appreciated, and you're looking to retire, and you're saying, look, when I retire, I don't want to sell this and pay the capital gains taxes. I don't want to just, I don't want to have to pull the money out and pay the taxes on that. Well, a charitable remainder trust is a tool that you can use to basically sell everything you've got, and I use the word sell, I'll put it in quotation marks, yet retain everything that you have, earn interest on it tax-free, and have it bulletproof from lawsuits. But it's primarily for bigger estates. So for those of you later on who decide to contact us and maybe you want to work with our people, if you've got that larger estate, you're looking towards retirement, that could be a powerful option for you to consider. We won't talk about buy-sell agreements or powers of attorney. We just don't have the time to do that today. But let's now move into the 3 areas of threats to wealth in America today. And these 3, they've just been with us forever, but they don't seem to get better. We are the most litigious society in the history of the world. Therefore, lawsuits is right at the top. And I'll just ask you a couple of questions about lawsuits. If you went to court today, how would it turn out? In other words, let's say an attorney walked into your room right now and said, hey, I've got a summons to court. Well, for most of us in business, that's a time to panic. We think, my gosh, what am I going to do? I've got to spend my time fighting this lawsuit. But we have a different approach. Most people will say, well, what you ought to do, if you're worried about getting sued, get some insurance. The more insurance you have in America today, the faster you get sued. There's more money there for the law firms. And in fact, there are some law firms in America today that never go to court. They know that, for example, if you're a doctor listening to this, you know that in certain specialties in the medical profession, lawsuits come by zip code. All they need to know is that you're a heart surgeon or you work with children or you work on very risky type of surgeries, and they're coming after you because they know just the threat of a lawsuit can get money. So what we would rather do is take a different approach. And that approach is we want to eliminate the possibility of the lawsuit, take the benefit away from the attorneys in the first place, not have to worry about the lawsuit, and then lower our insurances and put that money back in our pocket. So, I mean, think about this. If you're an attorney and you're going to sue somebody, and let's assume now, because we've done this in live format for so many years, let's assume that we've got all of you in a room and there's 100 or 200 or 500, sometimes we have 1,000 or more. And I say to you, if an attorney decides to sue somebody in this room, how does the attorney decide the first person to sue? Well, it's the first person who has the most that's the easiest to take. So we would like to have legally the least that is the hardest to take. So we want the attorney to look at us and say, never mind, I don't want to mess with you. And that is going to be the crux of things. In just a few minutes, I'm going to go into that specifically. And when I'm done with that, then I'll take you through each piece of what you own, each part of your estate, and tell you where to put it. It's really simple when you know how to do it. And this does highlight something too, and that is the fact that the legal profession in America is not in the education business. So when you go to an attorney, typically you say to the attorney, this is my problem, and the attorney says, this is what you need. But there's nothing in between that tells you why you need it or helps you understand it. So very few people walk out of their attorney's offices smarter than they went in. Poorer maybe, but not smarter. So what we want you to do is turn things around. For example, if you own a business today and you have employees, you probably give those employees a job description. If you're a doctor or a dentist, you may have assistants in the office, maybe the people who do staff work, maybe you've got nurses or other people. Well, you give those people a job description, you give them direction. What we want you to do is give a job description to your legal documents so that they know what they're doing and why they're doing it. And when you put your signature on the line, you know exactly why you've done it and you feel good about it. The second area that we're going to mention just briefly is taxes. Now, I don't have to tell everybody that taxes have gone up. My guess is in coming years, we're going to see some massive tax increases on federal and state. There's a whole lot of debt out there that needs to be taken care of. But the truth is taxes don't really ever go down. Most business owners give their wealth away time and again throughout their career because they pay too much in taxes, and they usually do it on the advice of their accountants or their attorneys. So I'm going to give you a question. When we get to the case study today, I'm going to give you a question to ask your attorney to determine whether or not you're paying too much in taxes. We've seen people save 10, 20, 30, 50, 100,000 or more in taxes by simply incorporating that. For some of you, it's something that your accountant is already aware of, but just didn't realize that you could use this tool in this way. So for many of you, you're going to find that your accountants also get the benefit of what I'm telling you today because you're going to make them a whole lot smarter. Now, the last area I want to talk about, or the third area, is probate. And this one has become the most damaging event in the life of a family in America today. So ask yourself this question. Now, if you're younger, think of your parents. But if you're older, think of yourself. If something was to happen to you today, right this minute, do you know exactly where every dollar you've earned in your life is going to go and how fast it'll get there? And if you don't, for most Americans, every day of our adult life is a financial surprise party. And the big one's on the family when you pass away. So you march down to your attorney and you say to your attorney, we have finally come to grips with the fact that we're not going to live forever. So we want to make sure that whenever we die, everything goes specifically where we want it. And let's say that you're like me. I've got 3 kids and now I've got a bunch of grandkids. And so I've got a lot of different people that I want to give things to. Well, how do I keep them from fighting over stuff when I pass away? Typically, you go to your attorney and your attorney says, well, you need a will. And in some states, you hear this advertised on the radio all the time. Do you need a will? Well, the answer is yes, but you only need it in the right place. Because here's what a will does. Number one, it requires that your estate be probated. Now, the exception here is if you have a very small estate, you don't own any real estate, maybe you don't have to be probated. But I'm guessing, because our audience has always been professionals, business people, entrepreneurs, etc., you have an estate substantial enough to worry about, you're not interested in giving it away or having it probated. Probate is a process, as you can see on the slide here, probate is a process where you turn your estate over to the legal system, and I call it chaos. Because once you turn it over to the legal system, you're out of the picture. Now, obviously, if it's a probate, you've passed away, you're not in the picture. But that will is what you are hoping will make sure everything goes to the right place. Well, unfortunately, there is an incentive for the legal profession to drag things out. And I can't tell you how many countless times I've had people in my audiences who have said, I went through a probate and it just dragged on and on and on, and I don't know why. The reason is the longer probate goes, the higher the attorney fees can be. Now, there are many, many very good attorneys out there who will do exactly what you tell them. But let's say, for example, you've got 4 or 5 kids and they don't see eye to eye, which probably they don't. Or maybe you've been married more than once and you're thinking, when I die, my former spouse isn't going to come after what I've got. But your former spouse's kids come after it. Or somebody else that's involved, maybe even a partner comes after your stuff. Well, in a will, everything can be contested and everything becomes public. You lose all your privacy. So I know a lot of business owners who will say, I've got family, I've got friends, I've got neighbors, I've got that irritating uncle. They've always wanted to know what it is I own. If you die with a will, they'll find out because it's immediately published. And then it goes into probate and everything can be challenged. So now your will says that you've got this painting, it's a great painting, and you want to make sure that painting goes to child number 2. And it goes into probate, and the other kids show up and say, well, we want that painting too. Now all of a sudden the decision is going to be made by the attorney or the judge who's hearing the case. So the decision comes out of your head. The other part is that all the costs must be paid before closing. Now, probate fees are really, really interesting. They vary by state. In almost every state, there are certain fees that are minimums that are set by the state. So to file this paper, file that paper, it might be $50 or $250 or something like that. But in virtually every state, and you'll see a disclaimer on the state's website that says these are suggestions to the attorneys. The attorneys are not required to follow these. So we've seen cases where people thought that they were going to have a quick down and dirty, be out of probate in just a few months, and they ended up billing thousands of dollars. Probate fees on average can run anywhere from about 1 up to as high as 10 to 12% of your estate. The IRS last year said probate fees are ranging closer to 10%. Now, to me, that's mind-boggling. That would mean if you had a $1 million estate, the fees are $100,000. And I would think that would be rare rather than common, but I'm not a probate attorney, so can't tell you that for sure. But I can tell you that if you have probate fees, and let's say now you've passed away, your kids are all sitting around the counter, everybody's agreed with everything, the attorney's ready to close the probate, and the attorney says, oh, by the way, that'll be $50,000. And they don't have the money. If they don't have the money, the court will order something sold to pay the probate fee. So now they sell a duplex or a piece of land or something like that, and they get hit with capital gains taxes. It could be 20, 25% or more, depending on the estate. Well, all of a sudden, that estate that you worked so hard to build for your kids is being taken away by people who are better prepared for your demise than you are. Now, the last point on the slide you'll see is federal estate taxes. I just want to bring this up. Most people aren't aware yet. I typically ask our audience, well, if you die today and you got hit by federal estate taxes, what's the percentage? What is the amount? Or what amount are you exempt? And people will say, well, $5 million, $6 million, $7 million, whatever. Under the new tax bill that was passed about a year ago, the federal estate tax exemption is a little over $17 million. That covers probably 90% of the people we speak with. But we do have people, it could be you. We do have people in our audiences who have families who built significant estates over the years. They've inherited large parcels of land, apartment buildings, real estate, boats, etc. And now they've got a estate of $25 or $30 million. Well, if that goes into probate, federal estate taxes are 47%. So any part of that estate above that $17 million that falls in the federal state side could get hit with 47% tax. So, and by the way, for those of you who have the larger estates, for those of you who have the larger estates, that's where that charitable remainder trust I mentioned in the introduction comes in. That's a tool you could absolutely benefit from. But there is an alternative here. When you look at a will, you say, look, maybe I do need a will, but my gosh, there's a lot of bad things to it. Is there a solution? Yes. The solution is a revocable living trust. Now, I want to be very specific here. A revocable living trust means you can change it. It's revocable. There are irrevocable trusts. Those are often insurance trusts, things like that. So we're not referring to those. The revocable living trusts have a lot of different things that you can have, AB trusts, etc. A lot of different trusts that fall in there. But the revocable living trust gives you absolute authority to end it anytime you want, but it does something else that's even better. It makes sure that what you want to happen happens. And that's probably the most important of all. It keeps your estate private. Now that, again, for some people is the most important thing. You have much more control than a will. Typically, if you put something in a revocable living trust and you pass away, it's going to happen. It should bypass probate, should eliminate the fees, the delays, the arguments, all the fights. You're going to pass the authority to the trustee after death. Well, what that means is, while you're alive, you still control everything in the trust. So you're not giving up control, but clearly the day you pass away, you want somebody you trust to take care of it. Now, for me, I use my younger brother to do this. I have people who use their banker. Some people trust their attorney enough to do it, but most people have somebody in their family that they trust to do it. Always a good idea to name two people, have one person and have an alternate, because if one of those people who's younger than you happens to have an accident or something bad happens, you want to make sure somebody's there to act as a trustee for you. You retain all of your tax breaks while you're alive. You avoid estate taxes. So if you've got that larger estate, you avoid that tax hit. And inside the estate, you do need a will. And as you see on the slide, it's a pour-over will. A pour-over will says it on the top, right at the top of the will. It says pour-over will. Listen to what this does, because this is so special. If you come from a family where maybe your patriarch or matriarch, maybe they're still alive. So let's say your parents in their 80s or 90s. and they filled out a will 10, 15 years ago, and you just can't get them to update it. And you're thinking, good grief, what's going to happen when they pass away? They bought and sold stuff. That will they have must be incredibly obsolete. Well, the pour-over will says even if you forgot to name something, it's automatically included. Think of the power of that. So the pour-over will goes inside the revocable living trust. And the way to test it out is, for those of you who already have a revocable living trust, when you have a chance, open it up. When you open it up, look inside for a pour-over will. If it has a pour-over will inside, you have a good trust. If not, maybe you need to fire the attorney. Cost-wise, by the way, the revocable living trust is a really interesting tool. It is the only legal tool that I know of that is almost fair traded throughout the country. Now, if you go to an extremely high-end attorney that works on $100 million estates, I'm sure these numbers would be out of whack. But most of us use either local attorneys or somebody who's with a larger practice, maybe has a local branch. Well, those attorneys, the revocable living trust tends to run from about $2,500 to $3,500 throughout the country. So it just seems like no matter where you go, you walk into a law office, you say, what does it cost to get a revocable living trust? They'll tell you $2,500 to $3,500. But one word of caution. Not only do you want to make sure the pour-over will is part of that revocable living trust, you want to make sure what they're going to charge you if you have a change in the trust. So for example, I had a person who told me at one seminar, he said, you're right about the cost. He said, I paid $3,500 for my trust. It was good. I thought my attorney set it up real well. I was pretty happy about it. But then I went to him to get a change. I sold something. I wanted to put something else in there, and he charged me $3,000 to make a change. So I'm going to recommend that if you're working with an attorney, and by the way, you do not have to use an attorney for your revocable living trust. If you have the form, you can fill it out, make the changes, get them notarized, and be done with it anytime you want. But if you do get one from an attorney, be sure to ask them what it's going to cost if there are changes to that trust. So that's the segment I'm going to do for you on wills and trusts, but it is really important. I hope you'll take it to heart. We've had so many people over the years sit in our programs and just tell us the absolute horror stories that happened because they had a will or they had a trust, nothing was up to date, they passed away, they had an attorney who just took leisure with it, and all of a sudden, they had a nightmare on their hands. So set up your revocable living trust. Everybody in the room should have one, everybody in your family. If you are married, there are many people in business who like to have one revocable living trust for the husband and one for the wife. This is a really good idea if you've been married more than once. So if you have two revocable living trusts, each one will say that the survivor retains 100%. That eliminates anybody from the other family, the kids from the other family, other marriages, etc., coming after what you've got. I also recommend that every year you review your revocable living trust. I do mine in December every year. Review it, take out anything, because you can just cross off something that you've taken out of it. Take off what is out of there, add in whatever is new, get it notarized, give a copy save a copy for yourself, give a copy to the person who's going to be your trustee. So it's not a difficult process, but the revocable living trust is really a foundation tool because every one of us is going to have a time when decisions are going to be taken away from us. Now let's move into the real reason that we're here today and what got us started so many years ago. And that's methods of ownership. How do you own what you own? How do you know that, for example, the legal documents you have today will do exactly what you want them to do? And are they okay? Well, let's talk about it. Under methods of ownership, a C corporation or an S corporation is for management and taxation. Now think about that for a second. There's a word missing in that definition, and that word is ownership. In America today, you would never, under any circumstances, allow a C Corp or an S Corp to own an asset that you're concerned about losing in a lawsuit. And the reason is it's up to the judge. Now the C Corp tends to be a little better than the S, but honestly it depends on where you are. There are some states in the country that are more litigious, more anti-business than other states, and those states will typically go right through your C Corp or your S Corporation. So if you were to go to an attorney and you said, look, I need a corporation to manage my business and give me tax advantages, then a C Corp or an S Corporation, either one of those can do it. A general rule of thumb here is if you're starting out, an S Corporation is fine, because when you begin, you don't have any net income, and that might serve you well for quite a while. Now, you don't change these things back and forth. You don't get an S Corp this year, a C next year, and then go back and forth. You typically do a change only when there are tax advantages or there are ownership advantages, maybe having to do with shares, partners, or something like that. You do that. But typically, the S Corp or the C Corp is for running your business. And again, if you're a doctor, you're a dentist, small business practice, many of you already have an S Corporation, keep it. Let it manage your business. But as you're going to see, the S Corporation can be a devastating tool if it owns an asset. In the case study we're going to do in a few minutes, the dentist who owned this practice also owned the building. And his accountant, because he misunderstood something, had put the building in the S Corporation. Well, this dentist had other dentists working for him in the building. He had patients coming in and out all the time. They shared equipment. I mean, one lawsuit by anybody, any patient, any other dentist in that building, he could end up losing the building and everything he'd worked for all those years. So you want to separate your assets, and again, we'll do that in the case study. The ownership of what you have should be in a limited partnership or an LLC. Now, once again, the limited partnership has been around over 100 years. Because of that, it has by far the greatest tax advantages and the greatest protection of any legal document because it's already fought the battles in all 50 states. It's been through the courts. It's been through the IRS. We are very fortunate today because the LLC has now been around long enough that there are some states that have already put case law on the books that gives a properly structured LLC almost the same advantages as a full limited partnership, and it's a lot cheaper and a lot easier to maintain. It is the preferred tool for anybody who does real estate investments, and as you can see, as you grow your business, it's a tool that you're going to want to use, and you're going to want to know where to put it. And this brings me to the next point. Let's say that you've built a business over the years. Excuse me, in this business, it doesn't matter where it is. Let's say the business is located in Texas, but you also have a branch in Delaware, and you have another branch in Oregon, and maybe you have some rental properties in Colorado, and maybe you've got a beach place down in Florida, and you're thinking to yourself, my gosh, I've got stuff all over the country, but if I get sued, they're going to go after everything everywhere, and maybe the property I've got in Colorado's in my name, and the one down in Florida is in my wife's name, and you're still thinking, I don't know, I've just got all this stuff, and I don't know where it should be. So let's talk about this for a second, and then I'm going to show you an inside secret that many of your accountants are not aware of. In fact, very few local accountants or attorneys are ever trained at this level of asset protection, and this is such a critical point. In a business, you have your assets and you have your business. So the business generates cash, the cash comes through and is used to acquire assets. Well, those assets are what you want to protect. So you can run the cash through your business and operate it wherever you're located. Like in this case, it puts you in Texas, doesn't matter where you are. But if I have assets in a variety of different states, I want the equity in those assets put where it's protected. What that means very simply is equity is personal property. That's your ownership. Like if you had $100 in your pocket, that's your $100. You can do what you want to with it. If you own a piece of property and it's got $1,000 or $1 million worth of equity, that's your equity and you can do whatever you choose to do with it. So what you should do is take that equity and put it where it's absolutely bulletproof from lawsuits. And that leads us to a topic that I ask in every one of my live presentations. I'll ask the audience to raise their hands if they've heard of this. Usually one person, maybe two people out of a large group will know it. And that is, how many of you have heard of corporation states? What an interesting concept. Corporation states. These are states that have very specific laws that are geared to protect businesses. There are 4 of these corporation states in America. They are Alaska, Nevada, Wyoming, and Delaware. You put your at-risk assets there. Now, before you jump the gun on this, you think, well, I don't want to go there. You don't have to go there. They have resident agents. So basically what happens is, let's say that you wanted to create an LLC and you wanted to own the equity in the real estate you own in Texas, in the vacation home you have in Colorado, and the vacation home you have down in Florida, and if you own the real estate under the businesses you have in Oregon and in Delaware, then you want it to own all of that equity. So you create the LLC, and in the LLC it says it owns the equities on these properties, these parcels, this business, whatever it may be. And then you simply mail that to the resident agent in the state you're going to use, and they will file it for you. Now the cost is insignificant. It's usually around $500 or so to file it, so the cost is nothing. So how does this work basically? Alaska and Nevada are the premier states for businesses to put their assets in. Why? They have the most case law. So 20 years ago, everybody used Nevada, but Alaska came along a few years ago and said, well, we'd like to get involved in this because for the states, it's a great source of revenue. Alaska now has even more case law than Nevada. So for our purposes, we typically use Alaska more than we use any other state. Wyoming is a very, very interesting one. Wyoming is the only state that has case law that protects the equity in a home. What an interesting concept. So if you live in a state where your property can be lost in a lawsuit, and that's all but about 12 states. Oh, really? There's only a few. There's Texas, Florida, Iowa, Kansas, Oklahoma, and South Dakota. In those homes, you cannot lose your home in a lawsuit. Now, this is a very important category because I've had people say, well, wait a minute, I have a homestead state. Well, if you're in a state like Pennsylvania, they're a homestead state, and their homestead protects about $800 of your equity. So it doesn't do you much good if you go to court. So we have people, particularly in coastal states where property values are extraordinarily high, or more maybe in states where they have large operating ranches, and the cost is not only high, but the land value is extremely high. And they're saying, this is what I want to protect. I mean, I could sell the business, I could lose the business today, but the real estate's going to retire me, and I don't want to lose it. So if you own it as the home you occupy, then you can send that equity to the state of Wyoming. We do not use Wyoming for anything else. And I'm only telling you this because I know if you have attorneys that are in Colorado or in Wyoming or nearby states, they typically put everything into Wyoming. Wyoming isn't bad for other assets, but it doesn't have nearly the case law that Alaska and Nevada have. We don't use Delaware. Now, I know if you're on the East Coast, your attorneys typically run straight to Delaware. We don't use Delaware because the costs are a little bit different. They are geared to very large companies. So if you're General Motors and you're Marriott, you're going to use Delaware. They're not bad, but Alaska and Nevada rise so far above everybody else that we just don't use those. But look at this here. This is really fascinating. 60% of Fortune 500 companies in America have a Delaware headquarters. As I mentioned, Delaware is really good for the very large companies. So a Delaware headquarters, if you're Monsanto, if you're General Motors, those kind of companies, that makes really good sense to you. But 90% of Fortune 100 companies have a Nevada headquarters. Now think about that. 90% of Fortune 100 companies, clearly they're not in Nevada. You don't have to physically be there. You don't have to have a bank account there. You just need to file your document there. So basically what these companies have done, this 90% of companies, they've said, look, we own assets that we could lose in a lawsuit. We also hire people that serve as our board of directors, our CEO, CFO, CIO, all the different critical players. If those people all had personal liability for everything that we do, they'd never come to work for us. So they set up the LLC, and all of the assets that could be lost in a lawsuit are now secured in that LLC, and now they can operate their business without worrying about lawsuits. And that brings us to a question that's probably percolating in the back of your head, and that is, well, why don't they have to worry about lawsuits? I mean, they can get sued like everybody else. Yeah, they can. I mean, the U.S. has 4% of the world's population. We have 90% of the world's lawsuits. So we're a litigious society. Well, the way you stop lawsuits is you take the benefit out of the lawsuit for the attorney. So let's take a look at how we do that. Let's say now you've set up your business and you have your properly structured LLC or possibly a partnership if you're a very, very large company, and an attorney comes along to sue you. And they sue you and they win. So it's not like they come up and they just stop on the point, but they win. Well, when they win, they can't issue a judgment. A judgment, as you know, is issued in most lawsuits. And for those of you who have been through this process, you know that a judgment doesn't mean that you're going to get paid. It just simply gives you the right to go after the money. So let's say now you had $1 million of equity. You have this properly structured LLC, and you get sued and the judge says guilty, but can't issue a judgment. What must be issued is a charging order. And this charging order has been through the courts in all 50 states. This goes all the way back to the lawsuit in 1961, and then it was firmed up in 1977. So let's take a look at this. And I just want you to just switch yourself on the other side of the table now. Let's say that you're an attorney and you decided to sue me and you forgot to do your research and you didn't realize that I have a very effective, very polished, very current LLC that's completely up to date. And you sue me and the judge says guilty and you think this is great. Now I'm going to go back to my accountant, I'm going to go back to my clients and I'm going to tell them I got it. And the person we sued has $10 million of assets consisting of real estate and gold and silver and all kinds of stuff like that, and also has about $100,000 cash on hand. And we're going to lien that. We're going to take everything he's got and we're going to leave that lawsuit in the books and we're going to do it until we either get paid or that person is ruined. I mean, this is the way a lawsuit works. But you just filed the lawsuit against me, you won the lawsuit, and you get ready to collect, and the judge says, oh, by the way, here's the situation. This is governed by a charging order. We could not issue a judgment. And under the rules of the charging order, you can't touch that person's assets in all 50 states. So now you got sued and you lost, but you have your business real estate in Texas. You've got a vacation home in Colorado. You've got one in Florida, and you've got land in Oregon, and you've got land in Delaware. And who knows, maybe you got a place over in Hawaii and down the Caribbean. I mean, we really don't know. And none of that can be touched, nothing. So think about this for a minute. If you're an attorney and you do a public record search and you find out that somebody's got properties worth $10 million in different states, but you can't touch it, do you sue them? No. This is why we call this preventative legal work, or I call it like brushing your teeth legally. You know, if you've ever been to a dentist, and the dentist looks at your mouth and says, boy, you got a lot of problems. But if you do a better job of brushing and flossing, maybe these problems would go away. Well, if you do it, they'll go away. If you don't, you end up back there with a cavity, toothache, an abscess, something really, really bad. Legally, it's the same way. We don't want to spend our days looking over our shoulders worrying about a lawsuit. We want the attorney to think, why would I sue him? There's nothing for me to get out of this. So they can never take your assets. But now let's go back to the beginning. You remember when I said that most of the LLCs that are created off the shelf today, you got it from your accountant, your attorney, they were LLCs created with two words in there called mandatory distribution. And those two words mean that they can take all of your money. So now they can take all of your money and they leave that decision on the books and they can take your money year after year until they're completely paid off. So that just defeats the purpose of having the LLC. Well, this is why we want to have the appropriate LLC. Way back in 1961, we created a paragraph. It's now paragraph 2.9 in our agreements. And this paragraph is going to give you the choice to decide. And here's the choice you have to make. You just lost the lawsuit. Technically, the person who sued you is entitled to all of your money. How much do you want to pay them? Because here's what your clause says. Your clause says the managing partner reserves the right to withhold all distributions of profit. So if you got $100,000, you can say, I won't pay you anything. And they have no way to go after you. This is the poison dart for lawsuits. Because if an attorney does the research before they sue you, as they always do, they search out the public records to see what you own. Excuse me, if the attorney does the research and says, well, if I sue you and win, I can't get your stuff and I can't get your money, you're thinking, well, why would I sue you? But there is still one flaw you have to address, and this is what makes the LLC such a popular tool today. If you look at this explanation here, it says, well, the managing partner reserves the right to withhold all distributions of profit. Well, if you have profit, there are taxes due. And that means if you get the profit, if you use the profit, you've got to pay taxes. But in this case, the person who sued you, because you lost the lawsuit, the person who sued you is entitled to your profit. So what happens here? Well, for the first, and I'm sure it's going to be the only time in your life, the IRS became your best friend. I'll give you a second to recover from that because the IRS has never been our best friend. But the IRS looked at this way back in the 70s and they said, well, wait a minute, we don't like this at all. Because under the provisions of this lawsuit, you lost But under the rules, you didn't have to pay them any money, so they don't have any money to pay the taxes. And since you don't have to distribute the money, you don't have any money to pay the taxes. We're going to fix it. So in 1977, the IRS passed the 177th rule or 137th ruling of the year 1977. When they passed this ruling, the Wall Street Journal said this limited partnership, because the LLC didn't exist back then, this limited partnership is now the only A-plus asset protection tool in America. Because here's what ruling 77-137 said. It says the creditor, this is the person who sued you, now must pay income taxes even if no income is distributed by the partnership or the LLC. What this means is when they sue you, they can't have your stuff and they can't have your money. So just put yourself now in the shoes of someone. You went to an attorney, you filed the lawsuit, the attorney said, this is great, I'm going to win this lawsuit for you. And the attorney calls you 6 months, a year, or 2 years later and says, hey, guess what? I won the lawsuit. I mean, I just killed them. I won everything you would want in that lawsuit. But unfortunately, you can't have any of their stuff and you got to pay their taxes. What is the attorney? What do you tell the attorney? You probably sue him for malpractice. This is the poison dart for lawsuits. This, by the way, and we don't have time to go into it today, this is the reason we have national companies. This is the only reason companies have been able to expand across state lines in America. Because if I have a business, a franchise, or any business that expands in 1, 2, 3, 4, 5, 6, 7, 20, 50 states, I mentioned Marriott Hotels uses our strategies. Marriott could never operate in all 50 states if they didn't have this protection, because they'd be getting sued in every single state, subject to the individual state laws, and spend all of their time fighting litigation. They would never be able to stay in business. So this is a monumental legal action that took place and was really firm for us back in 1977. So now in the few minutes we have left, let's look at how you can apply this. Now, if you haven't taken notes to this point, you may find it really, really helpful here because, maybe you can run this back later and play it again. But I want you to take a look at a blueprint that we created for people. And when I get done, I'll tell you how you can get one of your own if you choose to do so, or one we can create for you. The blueprint is a tool that is just basically a review by an attorney who looks at everything you have, sorts it out and says, well, this works for you, this works for you, this should be here, this should be there. And the blueprint I'm going to use right now is one we did with the dentist in Indiana, and this was some time ago. And this was a dentist who was very successful, but had reached a point where he said, I'm paying so much in taxes, I don't even know why I bother staying in business anymore. It's like I'm working for the IRS. And he thought, I'm still a young guy, I want to acquire more properties, I want to build some wealth, I want to retire early, but all I can see here is just tons of liability and a whole lot of taxes being paid. So we reviewed his estate, which he had a lot of pieces. And the reason I'm using him as my case study is because he had a little bit of everything. And every one of you in here can benefit from what he has and what he did. In the sample blueprint, we begin with the Revocable Living Trust. And again, I told you earlier, this is the legal tool that everyone in this room must have. There are no exceptions. You'll notice in the Revocable Living Trust, it has the interest in everything. So basically, you got an LLC with a piece of property, and it says in the LLC that when you die, the LLC dissolves, that asset goes through the living trust to the family. Very simple process. This is not a technical legal process. This is a simple way of explaining to people that what I want to happen is going to happen. So you write it out very clearly. Then we come over to the left side here, and you'll see the screen box with the dotted line around it. These are personal assets. These could be gold and silver, could be antiques, could be collectible items that you have. We have a lot of people. I had a man who had thousands of ounces of gold that he had collected over the years. Well, this becomes a significant asset and a great attraction to the attorneys, but it's not used in your business. And so if you own a business, you're saying, well, wait a minute, these are my personal assets. I don't want them to have access to them. So to secure them, what we did with this individual, because he had a very large amount, we set him up with a limited partnership, but we put the ownership of the limited partnership in the state of Alaska. And you remember Alaska and Nevada are the two states that protect the equity. So now an attorney comes along to sue him, does a public record search, looks at this and says, this is great. This guy's got millions of dollars of gold and silver and collectibles and all kinds of priceless things. All that stuff's negotiable. That's the kind of stuff we want to take in a lawsuit. The attorney pulls the legal document and discovers that all of the equity is sitting up in the state of Alaska. And if the attorney sues him and wins, he can't have the gold and the silver, he can't have any of the other items in there, but he's going to have to pay his taxes. So the attorney looks at that and says, well, never mind, I don't think I want to mess with that. Then we go to the right side at the top, and that's the business. And that for you that's the business you have today. When people write a check, that's where the check goes. So it's just your business. Keep it. That's where it goes. In his case, he had a dental practice, and it was set up as an S corp, and it was filed in the state of Indiana because he lives in Indiana. So whatever state you're in, that's where your business is filed. That's where a customer writes a check, the customer pays you. That's where it's paid to, and you'll keep that together. There was a mistake with him, and the mistake was his accountant also had the business building in that S corp. So I'll show you how we fix that in a minute. But first, I want to go to his home. He had a big, beautiful home in the greater Indianapolis area. He had bought it when the market was down. He said it's on a big lot. It's about 4 or 5 acres in a very prestigious neighborhood. He said the values have skyrocketed since I bought the property. It's worth several $1 million today, and it's nearly paid for. And he said, I know for a fact, because in Indiana you can lose your home in a lawsuit. He said, I know for a fact if I get sued, they're going to go right after the home. So we took the home, we put it in a Wyoming LLC because Wyoming protects the home. So now an attorney comes along to sue him, sees that LLC is in the state of Wyoming, can't touch him. So now his house is protected. And again, that's for a home only, the residence you live in. It's not a second home or a vacation home or anything like that. Then we go over to his business building. So he owned this 2-story building, and he had other specialties in there. He had basically started at the practice when he was fairly young. He had bought out the original dentist who retired. He had grown the practice, and now he had other specialists like endodontists and perios and orthos working in the building, and they shared equipment. And the building was in downtown Indianapolis, and if you know that area, it's been renovated. It's a beautiful area. And he was scared to death that if he got sued, the property would be taken because that's the most obvious asset, and he had all the other dentists in there working. He could get sued for something they did, or one of their patients falls down getting out of the building. So we took the building out of the S corporation, put it in an LLC, and I want you to look how this is put together. The LLC is filed in Indiana because that's where he's located, but look at the management of it. The ownership is in a management LLC. Now that management LLC, and he only needs one, that management LLC is going to own the equity, and we're going to then send that to either Alaska or Nevada to protect. But I want you to look at the bottom of that LLC also. You see it's called a disregarded entity. And this was his accountant's mistake. And by doing what we did here, he was able to save around $30,000 or $40,000 on taxes. I'm going to explain this to you in a second. But the first thing I want you to realize is every LLC is identical. So whether you have one LLC or you have 100 LLCs, every single one of them is the same. Filed in the state where the transactions are located or where the equity is. The management LLC is going to own the equity, and they are always disregarded for tax purposes. Down below that, you see the business equipment. Now, the business equipment in his case was x-ray machines and the dental chairs and a lot of the expensive equipment. They have dental offices. And since everybody used it, he had liability for everybody's use. So he was particularly concerned about that. So we put the business tools, not the real estate, but the business tools, the desks, etc., down in there. We see this very common where a company might have cement trucks, or they've got delivery trucks, and they'll put trucks down there in an LLC to keep it separate. So these are non-real estate items that are used in your business and could create a lawsuit. Now, before we finish this up, I want to say, when you look at this here, you should pick and choose and use the tools that fit for what you're doing. You don't create legal documents just to create them. So, for example, if you don't have any business tools, you don't create an LLC for business tools. We want to keep our costs down. Now, over here we had the problem and the solution. He had several pieces of rental properties in the Indianapolis area. He had inherited these properties, they were paid for, and he had gone to his accountant. He said, look, the other dentist in the office told me I should put these homes or put these rental properties in an LLC. And the accountant told him, and I've had people in virtually every seminar say their accountant said the same thing. The accountant said, well, wait a minute. No, don't do that because there's no reason to. The LLC is a disregarded entity, so we don't consider it for tax purposes. Well, that's upside down. The LLC gives you the greatest tax advantages of all. We'll look at that in a minute. So we took the properties, we put them in an LLC. Now, you could have one LLC for all 4 properties, or you could have 4 LLCs. What most people do is they separate the LLCs by liability, so they know, they just feel better. For example, they own a property with their brother-in-law, and their brother-in-law is pretty flaky. They'll create one LLC for that property to keep it away from everything else. But now look what we did. We created a management LLC. And if you look at the management LLC, you'll see that there's lines coming from the business building, the business equipment, and from the real estate that he owns, the rental properties. Those all go into the management LLC, which is filed, in his case, in the state of Alaska. And again, Alaska and Nevada are fine. So an attorney comes along to sue them and says, look, this is great. This is a dentist, and he's got this building, and he's got these rental properties that are worth several $1 million. We're going to sue him and get it all. Pulls the deeds and learns that the equity for these buildings is sitting in the state of Alaska. And if he sues them, his clients can't have the properties, but they're going to have to pay the taxes. So this is the poison dart. This stops the lawsuits. But now, for a second, look at the bottom and look how he's paying taxes. As a C Corp. This is what the Wall Street Journal calls the genius of the LLC. You may remember on the bottom of each one of these LLCs, it says it's disregarded. What the IRS says is, since the LLC is disregarded for tax purposes, you can choose how you want to pay taxes. Well, if I told you you could choose how you want to pay taxes, you'd say, I think I'll choose the way that saves me the most money. So what we did with him was very simple. We sat his accountant down. We said, last year you did his taxes partly as an individual, partly as an S Corp. What we'd like you to do is recalculate his taxes, taking everything he's entitled to under a C Corporation, and give him the advantages of those C Corporation, and just tell us, does it save him some money? In his case, it was more than $30,000. We've seen clients save hundreds of thousands of dollars. Now, usually in our live presentations, I'll go through a number of specific examples. We don't have time for that here. Our purpose was, to alert you to the three areas, taxes, lawsuits, and probate, that affect your business, and then have you look at this plan, and hopefully you can go back to this, maybe you can copy off what you need, and do the things you need to do. Now, for some of you, you've got a really good accountant, a really good attorney. You can go back to that person and get it done. If you don't, if you're interested in having it looked at a different way, just let me offer you a thought here. The problem and the challenge people face is, where do I begin? I've got to do business and personal planning. Am I doing the forms properly? All that kind of stuff. It's mind-boggling. You're saying, I've got a business to run, I don't have time to do all that stuff. So what I want to do is show you the plan that you can have here. First of all, you always want to get an attorney experienced in asset protection. The key here is to work with an attorney that's got experience outside of your state, in 50 states, because asset protection is a national challenge. Very few local attorneys are familiar with it. Always keep your documents up to date. That's going to be critical. We find so many people say, look, I filled out my LLC 5 years ago, and I don't know. You need to keep out documents up to date. Only use the legal documents you need, and you can choose those documents if you choose. Get legal advice before acting. Now, the last item down there says asapblueprint.com. When we created this, we tried to find something we could do that would be a direct benefit for you that wouldn't be very costly. And so what we created, and all of you can write that down, visit this blueprint, visit that page when you're done. We want to give you the option to call our offices, speak to our attorneys, tell them what you need, and have a blueprint drafted for you. So let them draft you a blueprint, very similar to the one we did for the Indiana dentist, and it's a very low cost. Again, we're not going to go into that part of it here. We just want you to see that there. But it's a courtesy we're offering you. It's something you can't do. It would cost you more than that just to go to your local accountant or attorney and ask them a question. So if you're looking at doing plans, or you just want to see if what you've got is right, go visit asapblueprint.com, see what happens there. I want to thank you for taking the time. I've always thought it's difficult to sit still for a live presentation of any sort, how well it's recorded or whatever. Hope you take the information you got here. Hope you apply it. Hope you let it make your business a little easier, a little more profitable. Thanks again for being here. Goodbye now.